In this session, we will see about the English mortgage and mortgage by deposit of titles and anomalous mortgage. Under Transfer of Property Act, Section 58E defines English mortgage. It says, where the mortgager binds himself to repay the mortgage money on the certain date. That is, the mortgager personally liable for the amount. He says that I will pay you the amount. Personally binds himself to pay the money on a certain date. Number one. Second one is, and transfers the mortgaged property absolutely to the mortgagee. The second part of the definition, this section says, he transfers the right in the property absolutely to the mortgager. Subject to the condition, this is the third. Subject to the condition, subject to the provision that he will retransfer it on payment of the mortgage money. So under English mortgage, there is a personal liability. The mortgager himself binds himself to pay the amount. He transfers the amount absolutely, transfers the interest in the property absolutely to the mortgagee. On payment, he retransfers this right to the mortgager. So it is like a sale. He sells it property and on payment of money, again it is retransferred. This is English mortgage. There is a personal liability. In mortgage by conditional sale, the transfer was ostensible sale. It is not an absolute. And on default, that has to become as an absolute transfer. Here, on the first day itself, it is transferred absolutely. All interest are transferred absolutely. Absolute transfer. Again, it is retransferred. There is another absolute transfer. But in mortgage by conditional sale, he transfers, it is an ostensible sale. Apparently there is a sale, but that gets the effect of absolute transfer only on default. There is a difference between English mortgage and the mortgage by conditional sale. In the simple mortgage, personal liability is there. Mortgage by conditional sale or usufructuary mortgage, there is no personal liability. But in English mortgage, there is a personal liability is there. Apparently, there is a sale in mortgage by conditional sale, but here it is an absolute sale. There is an ostensible sale at mortgage by conditional sale. In English, it is a absolute transfer of interest, and on payment, that person has to retransfer the property to the other person. Next is, we will see mortgage by deposit of title deeds. Section 58F. It is a mortgage by deposit of title deeds. Just deliver the title deeds and create a mortgage. Section 58F. We will see that. Where a person in one of the following towns, namely Calcutta, Madras and Bombay, or any other town which the state government concerned may by notification in the official gazette. So, where you can create a mortgage is defined in the section. Where a person in any one of the towns, that is Bombay, Calcutta, Chennai, and also places notified by the state government in the official gazette. In the official gazette, the state government has to notify that this place has been notified for creation of the mortgage by deposit of title deeds. For example, a state government may notify all municipal areas in our state are for creation of mortgage by deposit of title deeds. So, like that, the state government has to notify the places, plus the other three cities, that is Mumbai, Calcutta, Chennai. This is the first. Then first is where you can create. Second is how to create. Deliver to the creditor or his agents. Deliver to the creditor or his agents. Then what to deliver? Documents of title to immovable property. That is title deeds. Documents of title to immovable property. Then the fourth condition is with an intention to create a mortgage. So as per the section 58F, there are four things. One is the place. It says where you can create the mortgage by deposit of title deeds. That is at the places notified by the state government and also Mumbai, Calcutta and Chennai at the notified center. Deliver the document of titles to immovable property to the creditor or to his agent. Fourth, with an intention to create a mortgage. Now we will see in detail what are the essential things. One is the place. Place is essential. Other than that place, if you are delivering the document to the creditor, that is not a mortgage. For example, if there is a bank branch in a village where the borrower hands over the documents to the manager, then no mortgage is created. No mortgage by deposit of title deeds. The same thing, another borrower at a municipal corporation area hands over the documents to a branch manager, there the mortgage is created. So the place is important. It should be at the notified place. The state government notifies the places where the equitable mortgage can be created. First. Second, there must be a debt. So the last word is with an intention to create a security, with an intention to create a mortgage. If it is to be created as a security, there must be a debt. There must be a debtor and creditor relationship. The debt may be already availed or to be availed. For example, tomorrow the bank is going to extend a loan. Today the person can create a mortgage. Or he has already availed a loan without mortgage and the bank is going to give some more loan. For that purpose he is giving a mortgage. That means already availed and also this he can create a mortgage. The debt may be past or to be extended later. This is existence of a debt. Second is deposit of title deeds. The deposit of title deeds should be done by the person to the creditor or to his agent. It should be at the notified center, we have already seen. If it is with a copy of title deeds, then no mortgage is created. It should be with the original title deeds. This deposit of title deeds delivery, it is nothing, just a delivery. Even oral words are not required. By contact you are delivering these documents to other persons. Now what the banks normally do, they cannot show anything as a witness or evidence of creation of mortgage. They ask the people, the mortgager, to write a letter confirming that I called on you yesterday and I handed over the following title deeds pertaining to this property with an intention to create a mortgage to avail this loan. This paper they will be keeping it as a evidence, as a proof of creation of mortgage. This has nothing to do with the mortgage. As per the rule, just a delivery of document is enough with an intention of creating a mortgage. In case if there is any dispute on a future date, the banks do like this, getting a confirmation letter from the borrower. Next is intention to create mortgage. There should be an intention of creating a mortgage. it has to be proved that the documents were given with an intention of creating a mortgage. For example, if you are giving a document, a title deeds to the advocate, sir, you please check, you give your opinion about the title, whether the person giving the document is having a title or whether the title is clear. You give me your opinion, just giving. That is another thing. It should be with the intention of creating a mortgage, with an intention of creating a security for the loan availed or any other thing. That intention is required. Then next, regarding the registration. Section 59 of the Act says, any mortgage for a value above 100 rupees has to be registered, except mortgage by deposit of title deeds. There is an exception. It is just a delivery of the mortgage is created by just delivering the title deeds. There is no need for registration. Section 59 says. But however, some states make it compulsory for registration. Registration Amendment Act 2012 of Tamil Nadu makes it mandatory to register the mortgage by deposit of title deeds also. This is just a way to increase the government's revenue. It has to be registered in Tamil Nadu. Like this, some other states have also made it compulsory, like Gujarat. They made it compulsory for registration. Next, what is the remedy available to the person? It is only foreclosure. The mortgagee has to move to the court, file a suit, get a possession, and through the court they can go for sales. There is no personal liability in mortgage by deposit of titles, but banks normally take separate documents to make him liable for that also. If you compare this with other things, in simple mortgage and English mortgage there is a personal liability. Usufructuary mortgage, mortgage by conditional sale, and this mortgage there is no personal liability. No registration is required for mortgage by deposit of title deeds. This mortgage can be created only at the selected places, whereas the other mortgages can be created at any places. Now we will move on to the next one. Next one is anomalous mortgage. Anomalous mortgage is section 58G. Anomalous mortgage is these 5 mortgages have been defined in section 58. One is simple mortgage, mortgage by conditional sale, usufructuary mortgage, mortgage by deposit of title deeds, English mortgage. There may be some other mortgage which combines, which is a combination of these, any of these. That is not included here. Anomalous mortgage is a mortgage which has not been defined under the Act. That is why there is a section which says a mortgage which is not a simple mortgage, a mortgage by conditional sale, a usufructuary mortgage, an English mortgage, a mortgage by deposit of title deeds within the meaning of the section is called anomalous mortgage. A mortgage which will not fit into the definitions given in these 5 clauses, then that is a anomalous mortgage. For example, there may be a mortgage where the simple mortgage where possession is also given. Normally the simple mortgage possession is not given. But they may design a new thing, they may give possession also. Usufructuary mortgage, there is no personal liability. They may include personal liability in that. These all things are called usufructuary anomalous mortgages. Anomalous mortgage is a mortgage which will not fit into any of the parameters set by the definitions under section 58. May be a combination of 1 or 2 of the types. These are the kinds of mortgage. We will see the next chapter, next session, another topic.